got particulars about their sentence and that they were fairly relevant to the proceedings that are still ongoing. We have since got disclosure of material coming from them, and what we have asked for is disclosure of what transpired in court. Their credibility is an issue, the circumstances under which the statements came to be given, their plea deal, because you heard the sentences, and they are quite on the low side for this type of offense. So it was, we thought, obvious on the face of the record that there was a plea deal. The Crown conceded that there was an arrangement and that it was done pursuant to legislation, and that the record of the entire proceedings, inclusive of the transcript, is sealed. It being sealed by a judge of the court, there would be a process that we would need to go through. The judge today was mindful of the actions of her sister judge and would not wish to sit in appeal of that decision, which would be inappropriate of her, because she was not present for she doesn't understand the circumstances. So it is now for us to seek to get those records which we think would be relevant to the handling of these two potential witnesses in court if and when they come to the evidence. We have already received notice that the Crown intends to remand them, and we are of the view that anything touching and concerning them, their credibility, and how they came to give statements while accused persons is relevant to their evidence. They would have given these statements, and we wish to understand.
What is the process you intended to take next to access these?
It would require us asking for, even to ask the judge who made the order. But I would not wish to go into the process here. I would not wish to discuss the process here.
But it's a matter that you'll deal with right here at the Supreme Court.
It's a matter that we would wish to deal with here first. I'm not sure myself what happened. Today in court, as the Crown responded, was when I got an understanding as to what had transpired. I knew that something had happened, that counsel had been asked to leave, and that the DPP made press statements. I thought in light of her press statements, if you're talking to the press, you could certainly speak to the persons who are impacted by what you have done, in addition to the individuals who are of course serving their sentence. And we were told, no, this...
How do you think it might affect the case should you not get the files?
I'm not going to speculate as to how it may affect. Our intention is to try and put ourselves in the best position that we can in order to have a fair trial, and the courts here recognize that disclosure is relevant and essential to a fair trial. I understand that there are concerns about how the information is treated. We recognize that there would, of course, need to be care in the handling of materials such as this. I'm very mindful, and you're aware of that, in how I treat the information I get. It's given to me for a particular purpose. It's not for me to share with the public. It's for me to prepare myself so that we can make the best choices as we go forward in representing our client. The charge is a very serious one. They're charged with capital murder. And in these circumstances, we're of the view that every effort should be made to put the defense in the best position that it can be, so that the persons can say that they have had a process that was procedurally fair.